I had an intent to enter a suspended sentence of 15 years with the mandatory minimum suspended. The defendant said it was 30 days. The state didn't address it, so the oral pronouncing of the sentence was 15 years with 30 days suspended, or all but 30 days suspended. But the mandatory minimum is actually 2 years, not 30 days. The mandatory minimum was what was intended by the court when it issued its sentence. That issue could have been avoided altogether if I'd been more alert, or if the state had pointed out to the court the correct mandatory minimum. 46-18-116 sub 1 requires a written judgment. The only judgment that I thought I could issue in good conscience was one that said 15 years with all but 2 years suspended. Of course, then that creates a conflict between the oral sentence and the written sentence. In any event, last night, after reviewing all this again, I did execute the judgment that I thought was the only one I could, in good conscience, execute. So that judgment calls for 15 years, all but 2 years suspended. Then, at about noon, about 1 o'clock today, I get an order from the Supreme Court. And while the legislative branch may not be able to order the court to put its name on what it thinks is an illegal judgment, the Supreme Court can. And they said that we should vacate today's hearing and that I should enter a written judgment which conforms to the sentence orally imposed.